How do you get a bill back from the governor's desk? Once a bill's been passed by both houses of the California legislature, the bill is sent to the governor's desk for final action pursuant to Article 4, Section 8 of the California Constitution. In order for the governor to act on a bill, it must be presented to the governor for his or her final consideration. And this means, of course, that the governor has to have the actual bill before him or her in order to either sign or veto the measure. But once, sometimes twice during a legislative session, an interesting quandary arises. Can the legislature withdraw a bill from the governor's desk if the governor hasn't acted on that particular measure? The courts have generally ruled that the legislature may do so, but does this action apply even when the official records of the legislature reflect the bill was presented to the governor? And what happens if the governor doesn't want to give the bill back? Now, I want to explore these questions and actually propose a statute to address the retrieval process. Let us start by reviewing the main appellate court decision on this topic. It's Diasis versus the Department of Motor Vehicles that was issued in 2003 by the Third District Court of Appeal. The appellate court decision in Diasis was written by then presiding Justice Arthur Scotland, and it followed the passage of AB 60 in the 2001-2 California legislative session. AB 60 dealt with unlawful immigrants obtaining a California driver's license in this state. And amid widespread media scrutiny, AB 60 was passed by both houses of the legislature and presented to the governor on October 2nd, 2001. Now, the Assembly Chief Clerk retrieved AB 60 from the governor's desk after the Assembly unanimously approved a motion by the bill's author to withdraw AB 60 from enrollment and place it on the Assembly inactive file. The plaintiff, Diasis, in the case claimed that AB 60 had actually become law without the governor's signature. And the argument by the plaintiff was that after the measure was presented to the governor on October 2nd, that the governor had failed to act on the measure within the specified time limit that the governor's granted at the end of the legislative session. Remember, the governor has three options: sign the bill and it becomes a statute, veto the bill and it does not, or let the bill become law without the governor's signature. The trial court in the Diasis case rejected the plaintiff's argument. So did the appellate court. In that case, the appellate court said that the legislature and the governor acquiesced in the retrieval of a bill after enrollment, but before expiration of the 30-day time period allotted to the governor to deliberate on the bill. And the third DCA said, generally, courts will not interfere with that decision. In addition, the Third District Court of Appeal held that since such retrieval deprives the governor of the full period in which to deliberate on the bill, it cannot become law without the governor's signature because the bill has not been presented to the governor within the meaning of Article 4, Section 10 of the California Constitution. The appellate court further explained that the complaint alleges that the retrieval of Assembly Bill 60 from the governor was ineffectual because the chief clerk of the Assembly lacked the authority to do so. It follows the complaint claims that when the governor failed to act upon the bill in the 30-day time period allotted by the Constitution, it automatically became law. But the Court of Appeal said the governor acquiesced in the retrieval of Assembly Bill number 60. And then the appellate court opined, therefore, we are not concerned with whether the legislature can compel the governor to allow retrieval of a bill that has been sent to him, and if so, the circumstances in which or the formalities by which the legislature could do so. This is the essence of the legislative proposal set forth, or that I set forth. As the legislative branch also agreed to AB 60 being retrieved from the governor's desk, the court had noted both parties to the lawmaking function acquiesced in the retrieval of the bill. Neither of them asserts that retrieval was ineffective or that presentation to the governor was complete, and neither of them maintains that Assembly Bill 60 became law by the passage of time. So the court ruled that a private person's claim could not overcome the shared views of the two branches of state government in the lawmaking process. Now, what might happen in the obscure chance that the two branches don't share the same view on a bill's retrieval? Well, the appellate court explained that a bill is not presented to the governor unless it is in the physical possession of the governor for a period of time, not more than 30 days, that's necessary to permit the governor to deliberate on the bill during the presentation period. So let's talk about the bill retrieval. Because the legislature is vested with the exclusive authority to determine whether the formalities for enactment of a statute have been fulfilled, it would follow that a court cannot retry the legislature's determinations. And this is due to the fact that the lawmaking power of a statute is vested in the legislature, and California courts have repeatedly upheld the application of the so-called enrolled bill rule in the state of California. So when the chief clerk of the assembly or the secretary of the Senate retrieves a bill from the governor, then the clerk or the secretary curtails the presentation period required by the state constitution. And if the legislature determines retrieval was inappropriate, it can direct the chief clerk or the Senate secretary to promptly fulfill the presentation requirement by returning the bill to the governor with a full period for review of that bill. The courts in these cases should not second guess that determination. A bill's not presented to the governor unless it's in the physical possession of the governor for a period of time. Generally, the rule is not more than 12 days, of course, 30 days at the end of the session. And this is the time granted by the Constitution to permit the governor to deliberate on the bill and consider whether to sign or veto it. The governor's act of returning the bill to the legislature ends his or her time for deliberation, and then the bill itself is put beyond the governor's possession, and the legislature should be able to retrieve a bill after it's been presented to the governor. In the Diasis decision, the appellate court noted several times in its opinion that the legislature and the governor acquiesced in the retrieval of AB 60 after it had been presented to the governor, but before the 30-day time period allotted to the governor to deliberate on the bill had expired. So in this instance, clearly a court is not going to have the judicial branch interfere with that decision between the other two branches of government. However, I pose the question, what might happen if the governor doesn't acquiesce in the legislature's bill retrieval request? In other words, could the legislature still demand the bill be returned to them? Should both houses be required to request a bill be returned, or only the House of Origin, which is the current practice? The court in the Diasis decision said, therefore, we are not concerned with whether the legislature can compel the governor to allow retrieval of a bill that has been sent to him, and if so, the circumstances in which or the formalities by which the legislature could do so. So obviously, the Third District Court of Appeal left this question open for further deliberation. And as the appellate court described, by these actions, the legislature necessarily determined that the retrieval of the bill by the chief clerk was proper and effectual. It is not competent for a court to retry that determination as a question of fact. And because the Constitution does not expressly prohibit the retrieval of a bill once it's been sent to the governor, And since the governor and the legislature acquiesced in the retrieval of AB 60, we should not hold that the retrieval was ineffectual. So I'm going to suggest a statute for the legislature's consideration, and I propose that it be added to the California Government Code, perhaps as section 9508.5. I would say all bills shall be enrolled immediately following their final passage. An enrolled copy of every bill shall be printed and examined to ascertain that it is a true and accurate copy of the bill as it was passed by both houses of the legislature. The bill shall then be authenticated by the signature of the Secretary of the Senate or a designee and the Chief Clerk of the Assembly or a designee, and transmitted to the Governor or Secretary of State as the case may be. If at any time prior to the expiration of the period specified in section 9516, the Chief Clerk of the Assembly, if an Assembly bill, or the Secretary of the Senate, if a Senate bill, shall retrieve the bill pending before the Governor at the direction of the Assembly or Senate as the case may be, the Governor shall immediately return the bill to the Assembly or Senate as requested by the Chief Clerk of the Assembly or the Secretary of the Senate. So this statute would provide a specific avenue for a retrieval of a bill that's been passed by both houses of the legislature, regardless of whether both branches of government acquiesce in its retrieval. And as such, under this proposed statute that I've drafted, the legislature would be free to withdraw a bill from the governor's desk for whatever purpose, so long as the governor obviously had not yet acted upon that bill.